Good morning. Thank you all for joining again today. I'm Alycia, one of the professors here at the Law Center. And just a little bit of a misnomer this morning. When I originally discussed this, we were talking about estate planning, but we're actually going to do something more comprehensive on estate planning at a later time because that covers so many subjects. So what I want to do with this hour that we have this morning, especially for practitioners who are out there dealing with some things, I want to provide you with some updates as it relates to successions and donations legislation. Okay. So while we've been dealing with a pandemic, a lot has been going on in the realm of succession and donations. There have been quite a few notable cases that have come out since 2020. And I'm going to talk about a few of those cases, and I'll also provide a list of cases at the end of the presentation through the CLE department that'll be available to all of the participants. So just to kind of update you on some of the legislation before we get into the jurisprudence, with regard to small successions, there's Act number 44, and I'll include these as a part of the list that I'll provide. There is Act 44, a part of the 2021 regular session, and it's involving small successions. And what it has actually done, it is not a, what it is it's providing an amendment relative to the small succession affidavits, which will provide for easier access for banking accounts and so on and so forth than it has been in the past, where you can actually have perform a small succession rather than having to have the complete succession or the large succession done. So it's actually affects and reenacts revised statute 6767F and 768D. And it also involves Code of Civil Procedure, Article 3434. So I don't want to spend all the time kind of throwing numbers out at you. I'm going to try to talk to you in relative terms, which I'm going to provide you with it, but it's Civil Procedure Article 3434. So it reads something like this: a small succession affidavit shall constitute full and sufficient authority for the payment or delivery of any money or property, including property held in a safe deposit box of the deceased customer described in the affidavit, to the heirs or legatees of the deceased customer and the surviving spousing community, if any. So it's basically allowing the banks to transfer and move monies with regard to small successions. It's intended to simplify the process. Now, whether or not it is in fact going to do that, we'll find out. So also, just to kind of go in tandem with that, I'll bring your attention to section 768, which is the transfer of contents of the safety deposit box by an association to succession representatives, legatees, heirs, minors, and interdicts. And it basically is the same substance as what I just said. They will allow these transfers now by small succession affidavit. Now, that doesn't mean that the succession representative does not have to exercise whatever responsibilities and duties that he has or she has. It's just simply saying now that it's going to allow a transfer by use of a small succession affidavit. And again, I'll provide these updates where you can find them. And insofar as it affects Civil Code Article of, Code of Civil Procedure Article 3434, which is a copy of the affidavit authority for delivery of property, they've made the necessary changes again to reflect that now you can do these things by a small succession affidavit. Another change in the law that I'm not going to try to talk too much about because it goes into some of the estate planning is Act number 167 of the 2021 regular session. And it has to do with the Louisiana Uniform Transfer of Death Security Registration Act. And it is basically now allowing for a transfer form or a beneficiary form for transfer of securities that must be completed now in order to make a security transfer. And it's quite voluminous, but it's Act 167, 2021 regular session. And again, on my little cheat sheet with the list of the cases that we found some updates in, as well as, excuse me, changes in legislation, I'll provide that on that list. So what I'd like to get into is just jurisprudence, changes in jurisprudence since or in recent years. And the first case, of course, that I want to talk about is succession of liner. So this is about testaments and capacity form and other matters. We see some changes in the law here, or basically not even changes, but reinstatement or reinforcement of the law as it is. So the Liner case is a Supreme Court case. It's a 2021 Supreme Court case. So just the gist of it or the facts of it is that Mr. Liner, who's the decedent, had a notarial will that contained an attestation clause that did not precisely track the language in the code. And so it was close, but it's missing a few words. And the court held in this particular case is that, well, before I go there, I'm going to give you a little bit more about the facts. So in his instrument, instead of having the exact language of the code, it says something to the effect of the will was signed and declared by Mr. Liner, his name, testator, in the presence of these witnesses to be his last will and testament. And we each hereunto have subscribed our name. So basically they paraphrase the language instead of using it exactly as it is in the code. Because I think if you look at, and I didn't bring my code, so I can't look at it, but if you look at it, the wording is a little bit different because it names him as the testator, and then he makes this statement that this is his signature and where he's and who he's providing his signature in front of as these witnesses, and then we've all signed our names heretofore or something like that. So I'm paraphrasing, but you guys can go and take a look at it. And exactly. Thank you. And look, I have the expert here with me, so she can clear it up for me. But as Professor just said, it's actually two. There's an attestation for the testator, and then there's an attestation for the witnesses. And apparently, from the look at this, he tried to put it all together. He was tracking the language, but he tried to paraphrase and cut some corners. So what the issue before the court was whether or not the failure to have the attestation clause indicate that he had signed on every page and at the end of every page would render the will invalid. And they held that in this particular instance, it would hold as a valid will. Now, this wasn't the first time this issue had come up before them. They initially said no. And then they said, yes, we're going to go ahead and say it's valid, and we're going to allow for it. But this wasn't a unanimous opinion because and it was a close decision. And the minority felt that the attestation clause needed to be followed totally in the way that it's listed in the code, because then that would lessen the likelihood of there being some misunderstanding as to what the testator wanted held out with regard to his will. Because when he says that this is his last will and that he's signing at the end of each and every page, he is then affirming or as the affiant that this is actually what he desires to have happen. And anything less than that is a defect that could result in it being an invalid will. But the majority said no. Again, this is a change from what they have previously held. So it was interesting to me to see this case, and it's a 2021 case, slim majority saying that we will go ahead on rehearing and decide that this is enough. Person said no, now we say yes. So that's succession of Liner, and it's at 320 Southern 3rd, 1133. And again, it's a 2021 Supreme Court case. I'll provide those sites at the end of, well, I'll provide them to all the participants through the CLE office, okay? So another update is the succession of Bradley. It's a Fifth Circuit case for those of you that may not necessarily be practicing in the area of the law center, but it's a 2020 case. And this is also a question about form. You know, the Liner case was a form question case, and this is also a form question case. So just some background here. This decedent died in 2019 at the age of 87, survived by a wife of almost 28 years and 5 children from a previous marriage. The decedent's son filed a will the day after decedent's death that was dated a few days before his death. So the surviving spouse filed a petition to annul the will on the basis that the decedent lacked capacity when it was executed and that the decedent was subject to the undue influence of his children. She also challenged the will as to form. So after a trial on the merits, the trial court held that the will was valid. So she also stipulated to his capacity at the trial. So he had been sick in the last years of his life. His wife was a primary caretaker. She had had a good relationship with the children, and apparently at some point before the decedent's death, their relationship deteriorated. So when this case went up to, after the will was held valid, of course, the wife appealed. And the Fifth Circuit, yes, he left everything. He not only left everything to the kids, but I believe that the property that she had been residing in was property that he had before. So basically it was leaving her without anything. So she appealed, but for whatever reason at the trial, she stipulated to his capacity. So goes up to the Fifth Circuit, and the court held that, well, the court affirmed the trial court, and they said that the form was proper. The wife had argued that they did not see each other sign the will. So that because the witnesses didn't see him sign, it was invalid. That was her argument. But she couldn't ever bring a clear and convincing case to show that they did not witness his signature. That was, she made the allegation that his signature, and they said that that wasn't enough, and that what she presented was insufficient to rebut the presumption of validity. So she would have had to have something more than her belief. Now, she alleged that, she alleged that one of the witnesses said that they did not witness him sign it. And at the trial, the testimony of one of the witnesses was unclear as to whether or not the formalities were met. The witness initially said, no, I didn't see him sign it, but then said, well, before I signed my attestation, I did see him sign it. So it was kind of like, did you or did you not? Of course, that witness was found to be to lack credibility, because if you either you did or you didn't. And so the Fifth Circuit upheld the case. Now, with regard to the issue of undue influence, which is always something that I'm interested in, because I want to know how much is enough to say that someone has been unduly influenced. And in the words of one of my old professors, it depends, I guess, because here we have the influencers apparently were or allegedly were his children. And her testimony pointed to the fact that the children, as he got closer and closer to his death, started isolating her from him. They started interfering with the time that she would spend with him, getting him off by himself, removing her from conversations that she had previously been a part of, or taking care of him in the manner that she had previously taken care of him as his primary caretaker. And it was her belief that because they were doing this, they were leading him to believe that she no longer wanted to take care of him and was no longer interested in his well-being. Exactly, because it seems as if it was his separate property, and I don't see anything where she's saying this was his will prior to. So that's the interesting question here. What did she think she stood to gain? Because it seems that much of what he had, he'd amassed before they married. So Exactly, because her attorneys brought it before the court, and the court's going to answer the question. And I think the lack of capacity, considering the fact that she did have a doctor's statement saying that he was suffering from Alzheimer's, but that's not enough. She needed to bring the rest, and apparently she didn't. Exactly. The doctor can only say what he's been diagnosed with and what has happened, but the doctor didn't have any information that he could have provided with regard to his mental capacity at the time that he executed the will. So she testified that, they kept him from her, didn't want her around him, and because of this, she thinks this was an undue influence on him. Now, conversely, just as a point I wrote here on my notes, the doctor who did state that he suffered from the Alzheimer's did say that during the time that they were dealing with him outside of the Alzheimer's diagnosis, he did not have any other impaired mental state, and he didn't appear to be unduly influenced. He had complete understanding as to what they were doing with regard to his treatment, even though he had been diagnosed with Alzheimer's. So then that lends us to see or to believe that he had capacity and he wasn't being unduly influenced, and that even though he suffered with Alzheimer's, he had moments of lucidity where he could actually act and perform competently. So she lost that case. But again, I bring it up because it is one of the cases that I found in the search where they're attacking form or lack of capacity, and it's a recent decision, because oftentimes we have older decisions, we don't find anything that's changed. So this is a 2020 case, again, out of the Fifth Circuit. This next case is a First Circuit case, and it's a 2020 case, and it's Succession of Coon. And it's at 318 Southern 3rd, 947. And again, I'm not giving you these for you to scramble to write it down, just giving it to you contextually. So in this particular case, the decedent died in 2019. His daughter sought appointment as administrator, claiming he was intestate at the time of his death. His wife sought to probate a copy of the decedent's 2018 will based on the fact that the original was destroyed in a fire. After hearing, the trial court probated the copy and appointed his wife as executor. So, and their holding was that when a will cannot be found at the testator's death, there arises a presumption that the testator has destroyed the will with the intent of revoking it. That's the presumption. However, that presumption can be overcome by clear proof of the following: one, that the testator made a valid will, that the contents I'm tripping over my word, that the testator made a valid will and the contents or substantiality of the will reflects his estate. And then lastly, that the will was not revoked by the testator. So her production, the court held in this particular case, her ability to produce the will met the first two categories, because here is his will, it's a copy, and then it purports to deal with the contents of his estate. So the question became whether or not it was revoked by the testator. And so her argument was that when the house burned, the will burned in the house, and that it wasn't right, and that the fire was not caused by his act. It wasn't an intentional act. It was an accident, and he could not do anything to prevent the burning of the will. So also there was a credibility question in this particular case, because the daughter who sought to have the court appoint her as administrator because her dad was intestate was aware of the actual 2018 will when she petitioned the court to be appointed administrator because of his intestacy. So the court also weighed that and looked at her as a less than credible witness, because at the trial she admitted to knowing that he had in fact executed a will in 2018. Well, her argument was that he didn't have a will because it was destroyed by the fire. She didn't get into his intent, the daughter, but his wife presented a copy of the 2018 will. And because there, like Professor Reed just said, there wasn't any showing that he set the house on fire to burn the will and destroy it, then there wasn't any intent established on his part to revoke his will. So again, another one of those cases that make you say, did somebody tell you that this was the presumption and this is what you would have to prove in order to overcome it? Maybe not. So that's why we talk about these things at CLE, so that we can know that if we get clients that come into our office and tell us, well, the will was destroyed, it's important to understand that it had to be destroyed by the testator with his intention of revoking it. It cannot be destroyed accidentally or by some act of nature. For instance, a lot of people have experienced flooding. So if a house floods and the will floods out and you can't get to the original and you have a copy, that the flooding didn't revoke the testator's intent. So I just thought it was interesting for that reason to bring it up.
How did they do it? The assumption was that because they had it in their mind that they didn't want to because of someone on top of service. Argument that the woman
Well,
does say, when you do a will, all the language in it says revoke all of it.
well, I think that again, it starts with the consultation with the attorney. If the attorney has to be able to articulate to the client what the law is. Now, that doesn't mean that the client is going to want to concede, but I do think it makes for a better opportunity for them to have an understanding of what it is that they're dealing with if you're able to articulate the law to them. My first question to her would have been, how was the will destroyed? And did your daddy do it? Did your daddy destroy it? How did it happen? So okay. Right. Well, I haven't seen jurisprudence on it, but I have had a real life instance where this is a situation exactly what Professor Reed just explained. I'll repeat it so that if anybody didn't hear it, you can understand it. So Professor Reed is bringing up a situation where there's a decedent who has small children with an ex-wife. Okay, and then he has a new wife. No new wife, is two baby mamas. Okay, I'm sorry. Three baby mamas. I'm sorry. So then someone wants to be appointed administrator of his estate. Who's the best person qualified to act as administrator? Because remember, these minor children are his heirs. So where would you allocate administrative responsibility in that particular instance? Or let's just say decedent had a parent who wanted to be the administrator. So you have a decedent with a parent that wants to be the administrator, and then you have the person who is, or one of them who's actually the parent of the heir wanting to be administrator. Have you seen anything like that, Professor Reed? I have a lot of hearing that covers that.
Argument would be that
You have to say what person is not.
mother would be the best person. because he doesn't have a keen interest in his estate. All of the other people have an interest in his estate. You can't trust that it will be fair to the other people.
I think that argument could go both ways. Right. Right.
But what was the reason that she was not? What disqualified?
Well, it could have been a disqualification based on the type of finances it is. If she didn't have the knowledge to exercise, to be able to properly administer their estate, that's just like tutorship. When somebody tries to become the tutor because they're the parent, that doesn't necessarily mean, right, that you're competent to handle the estate. There is no bond. Right. Huh? Right. Wow. Right. That you're right, because they're gonna have to do something separate of her. Right. So just as a let's try to work through this piece that Professor gave us. So let's just say we have the decedent's parent who wants to be the administrator of his estate, and then we have a parent of the minor children who are his heirs that wants to be the administrator of the estate. As one of our learning colleagues just mentioned, there isn't a presumption that the mother, because she is the mother, should act as the administrator of the estate. And that case law has shown, our jurisprudence has shown, that depending on the type of estate and what all is involved in the handling of the estate, that person may not have the level of competency required to act as the administrator. So we had this little argument going back and forth as to who would best serve the estate's best interest. Would it be the decedent's mother, who really does not have a dog in the fight because the children are his heirs, she doesn't stand to gain anything? Or conversely, is it the mother of the heirs who would be protecting the rights of her children, who are the direct heirs? I haven't seen anything like that. So if anybody has seen anything that answers that question, let us know. But I believe it would turn into the same type of argument as to what the contents of the estate are, what type of capacity is required to administer it, and then which of those two people have the ability to do that. And depending on it, I have seen one case where this guy had a huge portfolio and he died with minor children, divorced. His children were the heirs, but the ex-wife was not seeking to be the administrator. It was a battle between his brother and his mother who were trying to be the administrator. And the court didn't allow either of them to be the administrator because of the complexities involved in his estate. They actually appointed a third-party administrator that was with Chase Bank, if I remember correctly. So I think the complexity of the estate is going to determine who would become the administrator at that point in time. But I think it is important to note, as was just mentioned, that there isn't a presumption that the parent of those minor children would necessarily be appointed as the administrator. But as we get all into this, as Professor Reed just pointed out as well, that's a ex parte process to be appointed an administrator. So they could all be trying to be appointed administrator, and then it's going to come down to a contradictory hearing. And at that point, that's when the court would take into consideration the estate and the contents and what it would require to actually dispose of the estate or to administer it for to the benefit of the heirs. So I mean, I think that's a good discussion, a good question.
You said it was multiple children. Our argument would be that before we even get to unbiased against the other children. All together.
Right. That's it.
Because they're against the law.
Money will bring folks together. They'll bring folks.
They all got together and said, we keep this money, girl.
That's what they say.
Because the mama get a hold of them, she can give it to them. But I think the grandmother would look after the interests of her grandchildren.
Yeah.
I would go for the grandmother. Then we get to the complexity of the thing. Make this
Well, you
qualify.
gotta come to that first.
Right. So
Another one was about,
Mhm.
and dad had never.
Oh.
Outside of court, came back. Now we have to go to the court to get the court to do it.
Mm.
You can't use the DNA test.
Nope. Right. You have to have the proper chain of custody when you do. Okay. Hold up a minute. Let me repeat the question. We have some, those participants who are remote can't hear the question. So the question is a situation where a decedent has a daughter who he's never formally acknowledged, but she takes action within 1 year of his death to be acknowledged. DNA testing comes back and verifies that she is in fact. Oh. Okay, so she had DNA testing with her aunt just to establish the connection, and now she has to petition the court to have this DNA testing done formally with the appropriate chain of custody in order to establish herself as his heir. So this is basically a chain of custody discussion. The fact that she had never been formally acknowledged, but within a year of her dad's death, she and the aunt did a familial DNA testing to establish the link. And now she has to establish it juridically, which is going to require a second DNA testing with the appropriate chain of custody in order to establish herself as his heir to what appears to be a substantial estate. All right. I'll repeat it when you're finished.
And when you requested now the father has passed. How he acknowledged, but that wasn't informal. It was an informal acknowledgement. Both two said, no, there was no formal acknowledgement. I got a hundred, but he
Right.
even the one that
Right.
informal, the one that he never. I'm representing the South.
Right.
So the
Right. So just to repeat for our remote participants, what we're talking about is what's required for acknowledgement, because she has an instance where there's a child who neither child has been formally acknowledged. One has an informal acknowledgement, which we call word of mouth. Oh, that's my son. He's always acknowledged him informally as his son, but never taken any steps to formally acknowledge him. And then there's another child that does not even have the informal acknowledgement. So this child who does not even have the informal acknowledgement has gone out and filed suit to take over the handling of the father's estate. Whereas the child push the child who has the informal acknowledgement out. And what we're talking about here, what we're advising each other on here, is that the proper procedural mechanism is for both of them to have to submit to DNA testing in order to establish their juridical link to the decedent. And that has to be done timely because, okay, so there is a suit already filed. Okay, so there isn't a restriction there. So as you can see, this can get really complex, and there isn't ever just a open and shut case. So one that I found that was kind of interesting is also a 2021 case, and it's succession of Landry. And for whatever reason, Landry has some significance in succession. You always find some succession of Landry with some drama. I don't know any Landrys, so I'm just saying what I saw. So in this particular case, the decedent executed a 2016 will, leaving all of his property to his daughter and named her as executor. In 2017, he executed another will that left his daughter the funds in his bank account and left the remainder of his estate to his nephew, and then named the nephew as the executor. So he made a switch. In 2016, everything was for the daughter. 2017, he does another will. He leaves her everything in his bank account, but he's no longer appointing her as his executor. He is now naming his nephew as his executor and giving his executor or his nephew the remainder of his estate. Of course, they had a dispute over which will was controlling, so they both filed suit. And the trial court determined that the 2016 will was valid and that the 2017 will was not due to lack of capacity. And of course, the nephew appealed because the 2017 will was his last will, which revoked all others, right? Prior will. So he says, hey, I'm going to continue to pursue this. So what happens in the Fourth Circuit, this is a Fourth Circuit case, the case ended up being remanded with instructions. And what the Fourth Circuit said was that the daughter bore the burden of proving by clear and convincing evidence that the decedent lacked capacity when he executed the 2017 will. It was her burden to bear. It wasn't the burden of the nephew, who was then the executor and the legatee to the remainder of his estate's burden. It was actually her burden to prove that he didn't. And it goes on to say that the decedent's medical records were apparently important to the case and admitted at the hearing, but however, they did not include anything to indicate the status of his mental capacity at the time of his death. And that it was important that it be understood whose burden it was to make the case. Now, what it doesn't tell me here, and I'll have to go back and look at it because it's one of the cases that I starred, what did they present on the trial court level to say that he lacked capacity? Was it just her testimony saying that he lacked capacity? Since the court is saying here the medical records aren't sufficient by clear and convincing evidence. So it appears as if she was the more credible witness to the trial court, but that there wasn't the substance behind it. And so the trial effect, that's what I call it, because they are the person who's looking at you and they're making determinations on credibility. So the Fourth Circuit is saying, okay, you made this determination, but we're going to remand this record to you for the purposes of you correcting the record. She may be credible and you can take her credibility into consideration. We cannot, unless we find clear abuse of your discretion, we can't overlook that. But what we can ask is that the record reflect this lack of capacity, that there be some type of corroborating evidence and not just her testimony that he lacked capacity. Mm-hmm.
Donated it to the show. Like capacity. Party judge. Because you had the lawyer to come in and testified that the man was in his right mind, but he could not remember if he read, and to this day, and I just was like, wow, but then when he had to go back, all the way up to the film, that he didn't take free with him. And all the medical rules, now that wasn't clear, but it's under medical records and all. And all this, it was like, I can't go back. Just gave up on that.
Okay. Well, let me repeat. So here we have an instance where we have a eventual decedent who prior to his death did act of donation or a donation inter vivos of immovable property to was she a relative? A non-relative. And at the time that the act was executed, this person was blind, did not have any type of photo ID. And the attorney involved advised the non-relative that he needed to have an ID. So she then pursued getting an ID for him that he could not sign for because he was legally blind at the time, returned to the attorney's office with the ill-gotten documentation, and they proceeded to do the act of donation inter vivos, transferring this property to her. And initially at the trial court level, the court said that he didn't lack capacity to make this donation and actually sided with the non-relative at the transfer was valid. The case was then taken up on appeal where it was reversed. And then shortly thereafter, Professor, you're going to have to give me the rest. Oh, okay. And then the opposing lawyer took other action to basically validate that transfer. So what's in that for us as we look at it in continuing legal education is this: if you have someone that comes to your office with any type of physical disability, any type of mental disability, there's loads of case law that says you have extra things that you need to do as a practicing attorney to make sure that you are able to corroborate that this person had capacity at the time that you actually executed this will. And I have personal experience with this because I had a lady that she was 89 years old, but she was sharp and she was well aware of everything that was going on around her. And she actually wanted to bequeath some things to a non-relative, but what made it so questionable for me was that the non-relative was her caregiver. And we hear all sorts of things about the caregivers and these non-relatives. And so this lady did not have the ability to travel. And so I was approached by, of course, the non-relative caregiver who wanted to get this will done, and said, well, she can't come in and she can't do this. And I said, well, I'm not going to be able to do it. I would have to be able to speak directly with her, have a conversation with her. And so I was told, well, we will pay you to travel. Okay, pay to travel, I'll come. So I went out and I met with this lady, and and I remember it clearly because at the time, Barack Obama was the president. He had just become president. And so she was very lively, but she was physically disabled. She could not move around easily. She couldn't do things, but she was very lively and had very good understanding. And so I was asking her about her date of birth and what year it was and what was going on. And she went on to tell me, I'm just trying to take care of all of these things because, they just elected Barack president. So I might be on my way out of here because I didn't ever think I would live to see this date. And then she started talking to me about all these current affairs and all these things that had been going on. And I wasn't a young lawyer at the time, but I enjoyed my conversation with her. She told me what she wanted her will to state. And then I had to go, of course, and prepare it and come back. So I was going to go back the next day and something said to me, you should write down everything that she said to you. What current affairs she talked about, what her state of mind was, how she introduced herself. She was able to tell me that I know this is going to upset my nephew that I'm doing this, but this is why I'm doing it. I mean, she just gave me a whole bevy of information. And so I did write it down, and she lived for another 5 years or so after that. So of course, what happens? The will is being contested because she had a substantial estate. I get a phone call to appear and explain, because she had been diagnosed with dementia. So I'm like, okay, yeah, I remember old lady, nice lady. And it was only my file that saved me because, of course, when I went back to the file and I had jotted down all the notes about everything she said, what her capacity was at the time, how she was able to discuss current affairs with me, and the fact that she was taking the steps that she was taking. And I didn't ever foresee when I did that will that I would actually be a witness at a later date. And I ended up having to be a witness to go and testify as to what her state of mind was at the time. Now, I couldn't testify to what her state of mind was an hour after she executed that will, but I was able to testify as to what it was when I initially met her, what she said to me, and then the second conversation we had when she actually executed the will, and I actually brought my own independent witnesses so that they could witness how her demeanor and how she expressed herself. And so I also had that as a fallback, the fact that I didn't have anybody who stood to gain anything that executed as a witness, and her will was upheld to the dissatisfaction of her family.
Second trip was the next.
Oh, you're right.
Talking about both trips, video.
Right. Well, that was good. So we have here in the audience someone saying that they also corroborated the witnesses' capacity and what they were told and how they were told by video. And so that is another option. And especially today with the ease it is to use your cell phone, you can capture a video rather quickly. I think at the time that I did this, I don't know if we had that capacity, but I didn't. So I had copious notes, and I was happy for those notes because I didn't think at the time that I would eventually have to be a witness. My concern was just having heard so much about elderly abuse by caregivers that I wanted to make sure that this lady actually wanted to do what she was saying that she wanted to do. And it led to, something completely different. Mhm.
Where no one would be taken. Everybody knew the judge, of course, but once he got on the stand, he started asking him questions. And tell and talking about that they do lose their power and then they fall back. Know it. I actually saw it for myself. Out after 5:00, I was telling the wife, I need to go because I don't want to sleep. So then the son has to come back, talk to him, bring it back to the place. And then he's okay. But it's a certain time every day. It's a certain time of day. I don't have children. 87. Not at that time, but when he's back in his true space, now I'm at my house. I have children with a daughter with.
Right.
And it's like I need to go to my house. And I was telling the children, I'm like,
yeah.
And I'm like,
right.
I mean,
Yeah.
It's a lot of wear and tear.
Yeah, it is. So let me update. We have a question here on remote that I want to get into, but before I do that, we're also sharing, and I know that we have a little volume problem. Professor Reed was just also sharing that the nature of dementia is such that these people come in and out of certain cognitive states, and that it could be time related. And I've also heard that it's activity related. So a lot of, if they remain in what's their safe space, they're able to keep their faculties together. But then when they start to travel or move around and get in unfamiliar states, then they lose their cognitive ability and they lose track of reality. So this is something else that you need to be familiar with as a practicing attorney. If this is your first time seeing this person and they have been diagnosed with some of these conditions or have certain cognitive limitations, when does this show up? How does it show up? How does it manifest itself? Because the family, like Professor said, is already dealing with a lot. And sometimes they are more hopeful than what the actual and factual dictates. And you have to remove yourself emotionally from it and look at what's required of you as an officer of the court in order to be able to do what needs to be done. And I'm sure that we've all been approached by someone at some point to say, well, mama's in the hospital and she can't talk right now and this and that, but you know how mama is. Mama would want me to have. Stay away from those what mama will want me to have situations, because they don't lead to anything except despair and destruction from what I've seen. Now we have a question in the chat, and I know that it was Mr. Richard that asked the question, and I think the question is, do we ever think that wills by recorded wills will be valid in Louisiana?
I think they will, because of unless there's a way to hack it, you can superimpose images.
It's gonna have to be by video too.
Yes, it will have to be by video.
Well, and are we saying video recording, Mr. Gavin? I mean, Mr. Richard?
Some states do.
Okay, well, I have here a consensus that they believe that video recordings will soon, would gain validity in Louisiana at some point, considering the changes in technology. I'll say this, some of the changes that are exceptions that were made during the COVID situation lead me to believe that it's quite possible that at some point we'll accept video, video recordings as wills, valid testaments or valid wills, because I was surprised at some of the things that we were allowed to do during this COVID, as far as notarial acts and so on and so forth. So I can see that we are moving in those directions. There's still the old school in me that says, nah, they're not, but after the pandemic, and my viewpoint has changed a bit, so it's quite possible. I believe it to be. All right, definitely will be some serious parameters. It's going to have to be able to withstand a review to make sure it hadn't been altered or doctored in any way. But I can see in the future that may be a possibility. Okay.
Before they did the video saying this is my last will and testament.
Okay.
Because Vincent's family, because he was his current wife, he gave her literally everything. When the children were trying to say, like capacity, that dad like capacity, and never given her everything because the prior wills gave everything to the kid.
Okay.
And then they had a big thing.
Okay. Well, that gives us a point of a research point. You look at the Benson litigation, because he actually videoed conversations with his doctors and his lawyers present so that they could actually have proof of his capacity and that he did not in fact lack capacity or suffer from any type of cognitive dysfunction that would have made his last will and testament invalid. And am I correct in saying, Professor Reed, that he also recorded his last will and testament? And his last will and testament was video recorded. So that's a point that we could go and take a look at. I'm gonna take a look at it. I didn't realize that. Now, Professor Reed brought up one other thing that I want to bring up to you guys, and again, I'll make it a part of the little cheat sheet. But interdiction is always fascinating to me because every time I've ever done it, it's always been some different thing that I had to focus on. I haven't done very many, but each time it's been different. There is some recent case law on interdiction, and I will also include that on the cheat sheet about the recent case developments from 2020 and 2021 as a part of the little handout that we'll send out and provide to everybody. I believe my time is up, so I want to thank you all for your patience in entertaining me. Thanks a lot. Thank you, Professor. Thank you.